Okay, now my guests agree that they want us to touch briefly on the KKD issue before we go to IMF and the utility bills that students are now supposed to take. Now, you know that KKD, the celebrated broadcaster, had been in trouble because one lady had something to do with. He says it was consensual sex. The lady apparently reported to the police that she had been raped, and a jury had been set up. A 7-member jury had been set up or constituted to hear the case. And they were going to hear the case because the Attorney General had insisted that even though the lady had said that the victim had said that she was not interested in the matter, they were going to go ahead to prosecute KKD. Now, we know what happened this week. The Attorney General went to court and threw in the towel, filed what we call a nolle prosequi to say we are uninterested in the matter. So KKD has been freed. The bail that he had, everything else has been quashed as a result of that. Egbert, that didn't come to you as news, really, did it?
At all. I think that there are certain key lessons that we all need to, learn from this. I know that, there are individuals involved, and as far as I'm concerned, these matters touch, nerve centers of, for example, the victim, KKD himself, and friends, family members, and the rest. Now, I believe that lessons have been well learned. I mean, going forward, everybody will be careful with some of these things that we all take for granted. Now, I will, on this bit, want to focus on the Attorney General's entry of nolle prosequi. I mean, nolle prosequi, we all know, is this, fiat of the Attorney General when there's a prosecution and the Attorney General feels that, there's no, for reasons, best known to her or whoever is the occupant of the office, that there's no basis for the prosecution to continue at any stage. The NP, as we've come to know it in short terms, will be entered.
The power is derived from Section 54 of Act 30.
Of Act 30, yeah. But you see, something happened in relation to the KKD nolle prosequi that I think, going forward, we need to be guided by.
Right.
You see that when the Attorney General entered the nolle prosequi, the office issued a statement.
That's right.
I want to relate that to Article 296 of the 1992 Constitution, which says that where in this Constitution or in any other law, discretionary power is given to any person or official, that discretionary power shall be exercised fairly, candidly, blah, 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 blah. It used to be the case that for highly contentious matters, our attorneys general in the past will just enter nolle prosequi and not explain the considerations that went into it.
Because the court has said that they were not bound.
That is so. They were not bound. But I think that there is what is and what ought to be. You understand? So I want to commend the Attorney General for explaining in a press statement, why it decided not to go on with the prosecution. And I pray that this standard should be maintained in every other matter, because there are ordinary cases in this country, and I use ordinary in quotes, where people bring a case before the attorney, to the police, Attorney General is prosecuting, the police are even prosecuting. All of a sudden, you end up in court one day, nolle prosequi. No explanation is given to anybody. When you do that, people don't start losing faith in the system, not in the judicial system, but in the prosecution system. And people want to take the law into their own hands. So I just want to commend the Attorney General, and I'll say it without equivocation, that this is a different style and it ought to be kept up.
Okay, thank you very much. But in 30 seconds, tell us, what's the difference in the nolle prosequi? Because some journalists had reported he had been acquitted and discharged.
Oh, okay. I think that for us lawyers, it is very clear. When a matter has not, as in a prosecution, has not ended to warrant an acquittal, so that in this case, the trial did not even commence, but the Attorney General entered nolle prosequi, all that it means is that KKD has been discharged. He has not been acquitted of the offense.
Right.
And so if tomorrow the situations change and the victim wants to speak, the Attorney General can bring an action. And the difference there is that when a trial, let's say KKD, the trial had gone and KKD had at the close of the prosecution's case or even at the end of the full trial been acquitted, then you can say he's been acquitted and discharged. And when you are acquitted, there's a certain advantage. There's something lawyers call prosequi,
right,
where you then, as the accused person who has been acquitted, you have a judicial shield protecting you that, as far as the same facts are concerned, nobody can bring any other charge in relation to them again.
That's
so
right.
Once the KKD cannot raise a defense of prosequi at this stage, he has only just been discharged. And so at any point in time, if it warrants that circumstances change and he should be brought back, he can be brought back.
Thank you very much. Now, James, there are those who say what Egbert says that we should all applaud the Attorney General for, and I applaud her for that. Ace Nkrumah has been asking for this for a long time, that we should stop that old era where we say, we just go and say we are no more interested, we file either nolle prosequi or withdrawal, and then we don't explain to anybody. This is very good. But there are those who say, in this case, we are explaining because it doesn't favor us. It is in our best interest to explain.
Well, Samson,
because when the lady said she was no longer interested, the advice was that don't pursue, and the Attorney General says we'll still go ahead with this.
No, I think I agree with my brother Egbert, and let me tell our viewers that Egbert was my mate in the law school, a very close friend of mine. We did so many things together. The Attorney General on this occasion did very well by making known why she entered the nolle prosequi, even though she wasn't bound to do so in law. Now, we need to look at the circumstances of this particular case to understand why it was imperative for the Attorney General to explain to the public why she entered the nolle prosequi. The way and manner the victim in the KKD alleged rape saga attempted to truncate the prosecution, for me, was unfortunate. Out of the blue, she wrote a letter stating that due to the fact that she was traumatized, etc., she wouldn't want to continue or allow the suit to be continued. Now, for me, I thought that that was a usurpation of the power of the Attorney General under the Constitution. You see, we must understand that criminal suits are not just prosecuted merely at the instance of victims. It is the state which is the party in those matters. And that is why criminal suits are entitled the Republic versus so and so.
Because it's a crime against all of us.
All of us.
And the state must punish it.
Precisely. And so for me, the reasons the victim sought to give just didn't hold water. I mean, was she not traumatized at the time she went and lodged the complaint at the police station? What must have been going on in her mind when she stepped forward and wrote a statement alleging that she had been raped by KKD? So I think that the Attorney General...
She did not expect that her name will be leaked in the media. She did not expect that photos of her will be splashed on social media and even, traditional media.
Well, she ought to have known that KKD is a celebrity, and journalists would be interested in a story like that, implicating somebody like KKD. So for me, the excuse that she's traumatized, it's a right to say so. But I think that the Attorney General also wanted to prove a point that, listen, I have a power to prosecute which can never be taken away from me regardless of the circumstances. Clearly, she demonstrated her willingness to prosecute. She gave the victims, the likely witnesses, the opportunity in the world to step forward and of course, testify in the matter to either secure a conviction by the state or result in an acquittal of KKD. Unfortunately, they didn't turn up. The Attorney General then came out to say she was mindful of the fact that in prosecuting criminal cases, one ought to take the interest of the victim into consideration. She also came out to say that, look, she had other options available to her. For instance, she could have compelled the witnesses to come forward and testify and then apply to the court to have them treated as hostile witnesses if they were to turn hostile. But of course, she allowed the overriding factor of the interest of the victim to prevail in those circumstances. So I think...
Don't you think that would have been a pursuit to lose anyway? You are pursuing something and you know you are losing.
Well,
because if you are turning witnesses into hostile witnesses, what are you going to get out of them?
Well, in some cases, you know, the punishment for perjury is, of course, deterrent enough. I have had occasion to apply to courts and got elicited very vital information and evidence from
if you have the evidence to show that somebody
witnesses.
If you have the evidence to show that somebody is telling a lie, use that evidence rather than use that person to tell you about that evidence.
Well, all said and done. Some said all said and done. I think that the Attorney General deserves commendation.
Okay.
KKD has come out to render an apology.
Right.
I think he has learned his lessons, and moving forward, those who like minds, like KKD, would learn from his example and behave themselves.
Okay, this is the statement.
No, he's rendered an apology.
This is the statement that was issued by the Attorney General. He says that the victim in this case, Erefe, is still very unwilling to testify in court. The victim states that she is highly traumatized by the incident, the events of the day, and its aftermath, and so is not in the right frame of mind to appear before the court. Thus, the Attorney General believes that it is not in the best interest of the victim and the prosecution to present her before the court at this point in time. The release continued to say that the Attorney General is mindful of the provisions under the Prosecutor's Code, one of which is that the best interest of the victim is to be considered in cases of this nature in deciding whether to prosecute a case or not. But they went ahead to give a caution that anytime she feels that she is willing to come and help, they would go ahead and resurrect that matter. The Attorney General actually added that other witnesses in this case, who are mostly family members of Erefe, are also very unwilling to testify. And so it makes the process very, very difficult for them. What do you say?
I think this is more legal, but I'll just make an attempt.
Right.
I think I'm going to look at it from the perspective of the interest of the victim. Because when you look at situations of this nature, three important factors or stakeholders' interests are needed to get to justice. The first is that when a crime occurs, the victim has a responsibility and a role. The alleged perpetrator has a victim, and when the community or the state in which that crime is committed has a role and a responsibility. If you look at it in this case, I think the alleged perpetrator expressed some extent remorse for what has happened, and promising that maybe something like that may not happen. So I think his particular responsibility has been discharged. And I think the state also made an effort, even though the victim was not willing to testify. And I think if you look at our criminal justice system, it is so much bent on establishing guilt and administering pain, more than considering even the interests of the victim. Okay. So I think to have done something like this in the interest of the victim, I think is fantastic. I don't know, but I think...
Do you know why they are laughing?
No, I don't.
When you say the criminal justice system is more interested in establishing guilt, that's what it's supposed to be doing, really. And
Reformation.
Yeah. Okay.
Yeah, I was thinking in most reformative cases, restorative justice.
I get you.
Yeah, okay.
Koku?
Well. The lawyers have spoken. Right. So what else can I say? Look, my friend KKD, and perhaps this goes for all of us in a way, he must seek strenuously to tame the animal in him. Okay? He must tame the animal in him, like all of us.
What kind of animal is that?
We all have animals in us. You don't control them, they can escape from your inside and create chaos. And the whole brand can suffer irreparable or potentially irreparable damage I like him. He's a nice guy. All of us. It goes for all of us.
You think his brand is gone?
Damaged.
Beyond repair?
I hope not. Because why? As long as there's life in you, you can make it again.
That's why some people even say that it would have been best if the trial had gone on and he was acquitted on the charge.
Yes, so, but it was also a drill. It's a real, real big drill. But the bottom line is that he must tame the animal in him. That's all.
Abdul Malik Kubaku Jr., when it comes to these issues, I don't want to comment about what he says. The last week he had things to say and he dominated social media discussion about certain roads to certain places and all of those things.